It went to.
All right.
They changed, yeah.
Okay, DRB, let's, we're missing Linda, I just realized.
Yeah.
Oh, we can, yeah, someone, we can
Where's Linda?
try to take some chicken scratches here. Let's call the meeting to order.
Yeah, and I'm happy to take notes.
Okay, thanks, Steve.
Yeah, I will need a pen.
At 6:31. First item of business is to approve this evening's agenda. Has everybody had a chance to look at it? If so, can I get a motion to approve it? Thank you, Sue. Second, Matt. All those in favor of approving? Aye. Unanimous approval.
I have to abstain over here.
That's right.
We're not at the minutes yet, but
Sorry.
okay. Moving right along to the minutes from January 16th. Everybody had a chance to go over the minutes. Any edits, comments? Hearing none, get a motion to approve the minutes. January 16th, 2025. Thank you, Matt. Second, Emily. All those in favor of accepting the minutes? Aye.
I will abstain.
Alec is abstaining as a member absent. Okay, public comments. Seeing,
We have no one on Zoom?
oh, good question. No one on Zoom, thank you. And so we're gonna move along to announcements and correspondence. I don't have any announcements. Any other announcements? Don't believe we've received any correspondence.
Nope.
Okay, we have a boundary line adjustment matter before us tonight. Is this a public, like, do we need to do
No, we do not.
we don't need to do the
We do not.
formalities of that? Okay,
This is a review of an administrative approval for this boundary line adjustment.
all right, thank you. You passed the test. That's just what I was gonna say.
Fantastic.
So we're gonna be talking about application number 2, BLA 25. The applicants are Eric Randall and I think it was Cynthia Randall.
That's correct. And for the record, the Randalls sent me an email on my request saying that they approve of Mr. Goodrich representing them at this matter. I'll put that into the file, into the record, but
Awesome.
they have granted permission.
Okay, great. Jeff, nice to see you. Why don't you, want to give us a brief little
Yeah, this is
summary here?
really simple, from my perspective, having been involved in all aspects of this from the driveway permit, from analyzing the site to identify getting wastewater. First, subdivision efforts, basically when Tom passed away, effectively within the changes, basically, Cindy said, hey, look, I want to preserve my housing my property, so I'd like to do this again. Doesn't change any of the stuff we did previously with respect. It's a novel thing that we'll get on.
Got it. So I read that, yeah, it seemed like it was kind of how she remembered the property and what she wanted to keep for the 514-100 lot. So did everybody have a chance to look at the schematic?
Yeah.
Okay, any questions for Jeff? Yeah.
This is such a ridiculous question, but Tom passed away.
I didn't know that. Yeah, he did.
So, did this just, I mean, how come his name appears here? Because he,
It's the estate, yeah, it's the transition of ownership from the co-ownership before to now. We essentially recorded the plan initially in these names, and so maintaining that to this.
That's the ownership on record.
Yes.
I see, so that
Yeah, having-
has no period.
Conveyed to an estate, that's correct.
Oh,
So in summary, there's, 0.6 of an acre in the kind of triangular shape in the back half of the lots, adjacent lots, transferring from 514, 120 to 514, 100, and a little tiny 0.05 acre up on the front half going in the opposite direction. And then, so the test, if you will, in our zoning regulations is that it does not have to be reviewed under the same criteria as a subdivision if the following tests are met. It's, Steve's laid out the criteria here for us. The land is less than half of the original parcel that's gonna be reduced in size, and that's true here. Both parcels already have development envelopes. Does not change the nature of the previously approved subdivision. Those are all, yeses. Does not result in the creation of any new lots. Yes, will not impair any access here. This is, like we said, at the back half. Will not impact adversely any valuable natural resource or result in a fragmentation of agricultural or conservation lands. That's true.
It is one thing I want to add, while we're good down threshold criteria, we need to amend the state, just so you all know. That's the next step.
The wastewater permit?
No, the subdivision, so
Okay, yes,
subdivision and wastewater, the wastewater is good, it's not an issue, but you see the percentage change from one lot to another. So following this, we've amended the H2 natural resources. Which,
Okay.
and that threshold's
uh,
2%?
it's a small number, Steve.
Yeah.
Sitting here, there, can't recall the exemption, but it's.
Yeah. It's
I
above
went
the
through this with-
exemption. Yeah. Just one point here, my interpretation of the word developed, is any lands that are created through a subdivision process. And, there's, I think, we're fortunate here that there's also a pre-existing improvement, which is what I think the word development in this context is doing. I think it's referring to improvements, and certainly in our definition of land development or development in our bylaws, it sort of talks about improvements to a property. This property has been improved by a driveway, but there's no existing residential structure or accessory structures. It's the only improvement is the driveway. So that makes it developed according to our definition. Though I would say, sorry, that's Linda. We might want to look at including in our development definition.
okay.
If that makes any sense.
Mhm.
Are you referring to the definition?
I am. And it's defined in several places. But it doesn't include at a minimum the creation of a parcel of land by a subdivision, which is how I look at.
Yes,
land
it's the
being
erection,
developed.
construction, reconstruction, conversion, relocation, or building exterior, sign or structure. Storage facilities.
Yeah.
So it is about building things.
Yeah, improvements on a piece of land.
There's no
And,
building.
so in this case, I sort of, yeah, and the fact that there is a driveway that has been built, it was sufficient for me to say that it fit our definition of development. Had that not been there, I think maybe a different proposition.
Okay.
Yeah. Yep. Interesting. Okay. Well, I learned something. I mean, I had a different, this is not to do with this. I thought there was some trigger about if you have it. So you know how we do development envelope reviews?
Yeah,
I had thought heretofore that it was like, it was undeveloped land and when you had a, development envelope blessed, somehow that might have had some kind of like tax consequences or something. So that was the kind of the trigger in my mind, was development envelope. So it's interesting, which is not physical, I suppose, but
true. And I think that would, the presence of a development envelope would be, developing the land.
it would be.
I would say so, yeah.
Okay. And we've just gone broader than Alex's definition there, though. So perhaps there's just more evidence that, like, let's clarify that in the next
Yeah,
rev.
So once there's a driveway or any improvement at all on a property, does the tax structure change for that property?
I don't really want to say, I don't know. I
Okay,
don't,
I'm just-
that's sort of the function of the lister to answer that question. They're the other side of my coin, so.
Okay,
You've got so much, again, this is nothing binding, but you've got so much experience. I know, just,
Yeah, so
what's your understanding of like
stepping away from
Yeah.
representing the client.
this thing? Yeah.
This one's interesting, because this is a farm initially. And so when, Scott gets out there, it's like, there's a what over here on the left. So I want to identify and stay 50 feet away, so we're gonna have to have the ecologist. And then with Eric, this is the great spot, it's great soils, how does it relate to Tommy? Parents' property.
Yeah.
So, I don't know what to say about being said, the question of development should be resolved.
Sure. But just from all your history here, if there's clearly an undeveloped in the general sense of the word, piece of land in Norwich, from what you understand, is there some triggering event that makes like a homestead portion of the tax? Like, does something that makes the tax really go up?
Ignoring tax, my issue is, the rules have changed so much over time.
Yeah.
If the DRB, since the DRB was constructed 2004, if the DRB says, hey, here's the development, we're not changing anything within that paradigm, I'm not too concerned about it. My problem is seeing parcels where the information presented for the development weren't real when they were approved. And Steve and I have talked about something, which I'm not gonna.
Yeah.
All right.
So in this case, this is real current rules.
Sure.
So let me just say, I've also seen a bunch of applications of the DRB, represented by architects and others that don't reflect real site conditions.
Different issue.
Also a fact. My sort of take on this is if the lands have gone through subdivision, the whole point of subdivision is to ensure that the outcome will be buildable lot. That's why, we make sure that there's septic capacity, that there's water, that you have access, all of the sort of fundamental building blocks. So I would, that in that process, that's where I sort of determined that it's been developed, right? Because those, very critical issues to, a building lot are reviewed. So
Right.
in a sense, you've developed the land, at least from an infrastructure perspective, via the process of subdivision. Further improvements, sort of go through a different process. I mean, you can build a house without any subsequent, like, real substantial review. The building permit application, and if you comply with the setback requirements, then you will receive a building permit. And that can only really be done with the sort of prior work in subdivision, making sure that there's septic capacity, water, et cetera. Yeah.
Cool. Well, we won't belabor, in the interest of time, maybe let's keep going here. Any questions for Jeff? I think, I think I maybe didn't mention the last thing. Neither lot is non-conforming after the
No.
change. So
Both lots remain.
it feels pretty, straight down the fairway. Cool.
I have a question. The Beverly Williams house, formerly Beverly Williams, is now occupied by one of the Randalls. Is that your understanding?
Hold on a second.
There's,
Is that? It's the house that's close to the road in lot 514.
Yes, that's Eric's parents.
That's,
Okay. Yes. Yeah, I forgot him.
Great. Do we have to, take any votes or anything?
I think you'll take a motion, to instruct the zoning administrator to issue, to ask the client to bring a final plat for a Mylar for recording.
Can we get that motion? Matt will make that motion.
so, here.
Sue, second it. All those in favor?
I,
Aye. Unanimous. Linda also.
Yes, I,
We know Linda did her homework ahead of time, so.
Yeah. And Linda, I'm taking notes, so no problem.
perfect. My apologies. I just had 7 still stuck in my head. And
Oh,
then,
right, totally. yeah.
and I was
Yeah.
gonna be early for 7, but I was late for 6:30.
Great.
Okay.
Thanks, Jeff.
Bye, Jeff.
Thought Linda was right. Sorry for all the fun stuff.
Oh, that's not my, that's all Ethan and you guys. Have fun with that. And he's in Colorado right now, so that's why he's not responding.
Okay.
Hey, Jeff.
Zoning administrator update and upcoming matters. Anything to add here, Stephen?
Again, I want to reiterate, if you guys have any, insights, ideas, suggestions for bylaw improvement, I'm open to them. Also, conversely, I don't know if I've shared with you the sort of work we've done already, in terms of, sort of specific amendments. Have I shared that with you? I don't think I have.
I know you were working on it the last meeting.
Yeah. So we, at our last planning commission meeting, we made some, so we're sort of like opening up, topics, sort of review with sort of initial questions, and then the members go back and sort of, take a deeper dive for subsequent discussion at the next meeting. So we've gone through, having sort of completed that discussion, we're sort of marking things off as having consensus and leaving them off the list for, further discussion. So far, we've sort of gotten this idea of lot consolidation off the list. The board has, the planning commission has consensus there. I think we're close with accessory dwelling units. Yeah, and there's a number of other sort of, things that are actually specific to the DRB, like offering the ability to review conditional uses that aren't explicit in a district. Right now, if you want to say construct a, for lack of a better example, a funeral home in the village commercial district, which I think is not out of character, that use is prohibited because it's not explicitly listed as a permitted or conditional use in that district. So the idea would be that the DRB could review, sort of applicant proposals for other conditional uses that they found to be similar to existing uses and, wouldn't on the face of it cause sort of bad outcomes for neighbors.
Sure.
Or the sort of character of the neighborhood. The other thing that we're looking that's sort of specific to the DRB is expanding the waiver authority, just sort of rationalizing the waiver authority. So in statute, DRBs have the ability to waive dimensional standards. So if you are encroaching on a setback, you could apply to waive that requirement. It's helpful in, village districts, in, other areas. And it's very useful authority for DRBs to be able to say, well, okay, if you comply with the following criteria, it's reasonable. Sure, we'll explicitly say we are waiving that dimensional standard. At present, we don't have that. Not as it's explicit in the law. There's some non-conformities that the zoning administrator can sort of ignore. But I don't think that's a really good process for that. It's not easily appealable. Whereas if we're explicit and, sort of take the authority that's given to us by statute, it's clearly, you can make a process to appeal that. We've got a couple of, Jeff has a couple of Pathways Consulting has a couple more sort of development envelope reviews coming in the pipeline. There's some tricky driveways that we're going to be looking at. Yeah. So yeah, that's sort of been, upcoming in the next couple of months. There's a development envelope review that I see coming for, I think a particularly challenging piece of property on Dutton Hill. We're right on the corner of, it's mostly it's a sheer cliff.
Which part of Dutton Hill? That's one of the.
Yeah, that's important.
Yeah, it's I would say
Upper, middle, or lower?
smack in the middle, absolute worst place.
Okay.
Absolute worst place. There's
Next to, on the parallel to.
Yeah.
it's Bragg goes like this following the stream,
Yeah.
Dutton Hill goes up,
Yeah.
and
Don't follow Google Maps.
No,
yeah, it is an incredibly steep and complicated piece of land.
Needs to be 3 different roads.
I would say so, yes. So
That's coming.
that's coming up.
Oh.
So we'll sharpen our pencils for that.
Can I ask a question?
Yeah.
Are you saying, if people want to put an accessory dwelling unit, ADU on their property,
Mhm.
of course they have to get a permit, right?
Yes, yeah,
Are you seeing an increase in that?
that is the most common conversation that I have.
Good.
And we're, our bylaws as written right now do not comply with state law at all. My predecessor Kyle would attach a letter of opinion saying, I'm allowing this. So just to back up, Act 47, the Home Act, made it so bylaws have to treat accessory dwelling units as they would treat a single family home. So by right use in most districts across the state.
So my question is, are existing accessory dwelling units installed before the current regulations, are they grandfathered in?
I don't like to use the term grandfathered. I like,
Grandmothered in.
it doesn't have a great context, but I like to refer to them as pre-existing, non-conforming,
Yeah, okay.
pre-existing non-conformities. Yes. Yes. Yeah. And there's a lot. I mean, we have there's a lot of accessory, detached apartments and, above garages
Yeah.
that have been there for 25 years.
Yeah,
So, maybe one of yours.
yes.
Yeah. So, yeah, I mean, we're not going to go back and relitigate any of that stuff.
Oh, that's
Those
so
are
nice
fine.
to hear.
It's all good. Yeah. We're moving these things forward. I'm also looking at some of our overlay districts. In particular, the shoreline overlay district, which is very convoluted. And I met with the Conservation Commission this week to get their perspective on, how to create a sort of riparian buffer that does the work of the overlay district, but is easier to work with and more flexible to sort of changing conditions. Or I'd also like to move the flood hazard regulations into its own article and leave this, move away from having a flood overlay district and flood hazard regulations and just put it all under flood hazard regulations. The overlay is the FEMA floodplain and,
It's important to clarify what is development. Again, I'll just use that word for the flood overlay district, because we had a
Yeah.
case a few years ago where like someone was building a tennis court with this fence within it. Yet we were like nitpicking about like the house compared to that, which was way out of the flood district relatively. But like they didn't even consider the downstream effects of like what putting a chain link fence
Yeah.
within a
Yeah.
flood district was.
yeah,
Or impermeable ground within a flood district.
yeah,
That really
yeah,
hamstrung
yeah, yeah.
us. That made our whole thing seem foolish.
And, we're sort of working at on these things at a good time. Two Rivers, some funding to review, floodplain regulations for municipalities in the district. So they offered to look at ours at the same time. So, we've had a couple of eyes on that already, just to make sure it's compliant with, sort of the National Flood Insurance Program regulations and all of that. So, yeah, simpler to use. That's the whole goal here, is to make these bylaws simpler to interpret, simpler to use, not just for the DRB, but for somebody who wants to understand what they can do with their property.
Mhm.
Speaking of which, I did notice there are two sets of definitions,
I know, I know.
and they're not the same.
They're not the same.
either.
No.
Odd.
It is odd. It is odd. That is teed up for, removal.
Okay, that's probably good.
Yeah. There's a lot, that's not the only instance of sort of conflicting information, in the table of, setbacks for, districts, we specify setbacks for rivers and streams, but in the shoreline protection overlay, we also have explicitly named, distances. So it's,
In the document we were looking at today, in the checklist, it was like both lots meet the 2 acre minimum necessary for rural residential. Yet there's another calculation metric that you plug in your property when it comes to like distance from town hall, this, that, and the other, which makes it so that when you actually plug that stuff in, there's a lot of rural residential where 2 acres is not the actual minimum. Like the Randall spot, based on that calculation, I'd be surprised if 2 acres was the actual. lot size.
yeah, I mean, I don't, I agree with you. It's,
But 2 acres is what you need in order to subdivide, in
Right.
order for a house to be built on an envelope. to be-
yeah, yeah.
It has to be minimum. 2.
Yeah, so if the calculation comes up with something smaller,
Yeah, but 2 acres is the minimum possible.
Yeah.
But when you actually, when your rural residential, that's like the closest you could possibly be
Yeah.
to town.
everything's rural residential. It's like 80% of the land mass in the town of Norwich is rural residential. And, the subdivision,
Like 20 acres, what it supposedly is for my house when you plug it in, which is absurd.
yeah, I find it very, very effective at limiting development.
Yes.
Yeah.
For certain parts of town.
For many parts of town.
Yeah.
Many circumstances, and, but that is the stated intent of the subdivision regulations. It says, the intent of these regulations is to limit development, and it does.
I guess that's why you have regulations, all regulations limit development. If there was no regulations,
Yeah, I don't know where it falls.
Right.
This harder thing would be limit development and encourage development in appropriate places.
Yeah,
That's the other side.
yeah,
But yet, we can't get that land down on Route 5.
that's another aspect that we're looking at is,
Please look.
so the other conditional, we're also sort of expanding our, inclusion of agricultural uses. So there's the accessory on-farm business, which is this, and we have a number of those that are operational. So what that means is if you are a designated farm, designated by the Department of Agriculture, there's some scope for a retail-like operation. And, you know, there's a bunch of rules that, you know, there's qualifying products and all of this, but, we don't, well, I mean, we have a lot of that use, but we don't have any of that regulation built into our bylaws. We're looking at exempting, from permitting, like roadside agricultural stands, that are temporary or seasonal in nature. So if you want to sell eggs, please do. You know, and you can put up that little, you know, shed and you don't need a specific permit for that. And the other thing that we're looking at is creating a definition for an open air market, which would accommodate the sort of, you know, uses similar to the accessory on-farm business, but are not on a farm, so to speak. So there's a couple of those in town. Yeah, well, there's the North Farmers Market. And then there's the sort of farmers markets also on Route 5, just Crossroads, which, you know, it acts as an accessory on-farm business, but it's not on farm. So.
Any tax.
Yeah, you know, I mean, there's generally like, you know, temporary events such, you know, like tag sales, yard sales, all that kind of stuff are explicitly exempted. You can up to a certain number a year for a certain amount. There's some criteria. Usually.
That's good.
But yeah, that's what we're working on.
Okay,
Thank you.
good update. I think we're ready for adjournment.
Yeah.
Thanks. Nice to see everybody. Close the meeting, 7:03.
As nice as this is, I don't know why in these places with all their things get checked, why we.
Even getting, I know.
Yeah, it's an oddity. You know, it's sort of like administrative, not administrative approval. I don't, but that's the way they're written, you know, I mean, I would love to not have you guys come in for this kind of stuff. I mean,
Send us out the packet, we could click thumbs up on the email, I feel next.
yeah, we can't do that though. It's gotta be done in open meeting.
By the state or by the.
By just best practice. I mean, we can't conduct business by email. It has to be in an open meeting.
But
Meeting law.
This is not a hearing.
But, sorry, going back to open meeting law, we don't have to record we don't have to record our meetings.
Here. Hey, wait. Yeah, wait a
Linda?
second, you know,
Oh.
nobody actually made a motion and seconded it, and we didn't
I
vote
will
on
do it
adjournment.
during the meeting.
And I'll second. Okay, Don said.
All those in favor? Thank you, Linda.
Parliamentarian.
It's just because I have the minutes form.
There's,
I only say that because the cemetery commission, I'm like, oh, God, how are we gonna record it? Okay, we gotta get a Zoom, and so. No, I do minutes, and then.
I don't, you know, it's you know, whether the cemetery commission is advisory, non-advisory.
It's not a town,
Out the front.
I
Yeah,
mean, it's not like,
I think so.
it's its own.
See you
committee
back up on the hill.
that,
Yeah, actually, we can go upstairs in the ramp.
You know,
I
The way
if you understand it's not, I'm gonna stop.
that's why
recording.
when I read the.
Thank you, guys.
When I read that, I was like, oh, thank God, we don't have to record it, but, you know, we record the meetings, we publish the minutes.
Yes, thank you.
Where it's open to public.
Bye, Linda.
Bye, Linda.
Bye.